Hi friends, today we are going to see a new topic on President of India. President of India, Bharat Ki Rashtrapati, is the head of the state of the Republic of India. The President is the nominal head of the executives, the first citizen of the country, as well as the Commander-in-Chief of the Indian Armed Forces. Draupadi Murmu is the 15th and the current president, having taken the office from 25th July 2022. The office of the president was created when India officially became a republic on 26th January 1950, after gaining the independence on 15th August 1947. When its constitution came into the force, the president is indirectly elected by an electoral college comprising both houses of the Parliament of India and the legislative assemblies of each of Indian states and territories, who themselves are all directly elected by the citizens. Article 53 of the Constitution of India states that the president can exercise their power directly or subordinate authority with few expeditions. Though all of the executive powers vested in the president array in practices exercised by the Prime Minister a subordinate authority with the advice of the cabinet ministers. The president is bound by the constitution to act on the advice of the Prime Minister and the cabinet as long as the advice does not violate the constitution. The origin. India achieved independence from the British on 15th August 1947, initially as a dominion within the Commonwealth of the Nations with the George VI as king, represented the country by the Governor General. Following the independence, the Constitution Assembly of India, under the leadership of B.R. Ambedkar, undertook the process of drafting a completely new constitution for the country. The Constitution of India was eventually enacted on 26 November 1949 and came into the force on 26 January 1950, making India a republic. The offices of the monarch and the governor generals were replaced by the new office of the President of India, with Rajendra Prasad as its first incumbent. India retained in the Commonwealth membership per the London Declaration, recognizing the king as the symbol of the free association of its independent member nations and as such as the head of the Commonwealth. The Indian Constitution accords to the President the responsibility and the authority to defend the and protect the Constitution of India and its rules of law. Invariably, any action taken by the executives or the legislative entitles of the Constitution shall become the law only after the President assents. The President shall not accept any actions of the executives or the legislators which are unconstitutional. The President is the foremost, most empowered and the prompt defender of the Constitution by the Article 60, who has an preemptive powers for ensuring the constitutionality in the actions of the executive or the legislators. The role of the judiciary in upholding the Constitution of India is the second line of the defense in nullifying any constitutional actions of the executives and the legislative entitles of the Indian Union. The powers and the duties. Under the draft constitution, the presidents occupy the same position as the king under the English constitution. He is the head of the state but not of the executive. He represents the nation but does not rule the nation. He is the symbol of the nation. His place in the administration is that of a ceremonial device on a seal by which the national decisions are made known. The duty. The primary duties of the President is to preserve, protect and defend the Constitution and the law of India as made part of their oath through the Article 60 of Indian Constitution. The President is the common head of all the independent constitution entitles. All their actions are recommended by the Article 3, Article 11, and Article 274 and etc. And the superiority power through the Article 74 to Article 78C, Article 108, Article 111, etc. over the executive and legislative entitles of India shall be used in the accordance to uphold the Constitution. There is no bar on the actions of the President to contest in the court of law. Legislative power. The legislative power is the constitutionally vested in the Parliament of India, of which the President is the head to facilitate the lawmaking process per the Constitution through Article 78, Article 86 and etc. The President summons both the houses of Lok Sabha and Rajya Sabha of the Parliament and procures them. They can dissolve the Lok Sabha. The President inaugurates the Parliament by addressing it after the general elections and also at the beginning of the first session every year per Article 87(1). The President addresses on these occasions is generally meant to outline the new policies of the government. All bills passed by the Parliament can become a law only after receiving the assent of the Presidents per Article 111. After a bill is presented to them, the President shall declare either that they assent to the bill or that they withhold assent from it. As a third option, they can return a bill to the Parliament if it not a money bill for reconsideration. President may be of the view that a particular bill passed under the legislative powers of the Parliament is violating the Constitution. But they can send back the bill with a recommendation to pass the bill under the Constitution power of the Parliament following the Article 368 procedure. When after the reconsideration the bill is passed accordingly and presented to the President with or without the amendments, the President cannot withhold their assent from it. The President can also withhold their assent to a bill when it is initially presented to them, rather than return it to the Parliament, thereby exercising a pocket veto on the advice of the Prime Minister or the Council of the Ministers per Article 74. If it is an inconsistent with the Constitution, Article 143 gives the President the power to consult the Supreme Court about the constitutional validity of an issue. The President shall assent to the constitutional amendment bills without power to withhold the bills per Article 368(2). When either of these two houses of the Parliament of India is not in the session, and if the government feel the need of an immediate procedure, the President can promulgate ordinances that have the same forces and effects as an act passed by the Parliament under its legislative powers. They are in the nature of an interim or the temporary legislations, and their continuance is subjected to the parliamentary approval. Ordinance remains valid for no more than 6 weeks from the date the Parliament is convinced until they approved by its earlier. Under Article 123, the President as the upholder of the Constitution shall be satisfied that immediate action is mandatory as advised by the Union Cabinet, and they are confident that the government commence majority support in the Parliament needs for passing of the ordinance into an act, and Parliament can be summoned to deliberate on the passing of the ordinance as soon as possible. The proclamated ordinance is treated as an act of the Parliament when in force, and it is the responsibility of the President to withdraw the ordinance as soon as the reason of the proclamation of the ordinance are no longer applicable. Bringing laws in the forms of an ordinance has become a routine matter by the government and the President. But the provisions made in the Article 123 are meant for mitigating unusual circumstances where immediate action is an inevitable when the extant provisions of the laws are inadequate. Reproclamations of an ordination after failing to get an approval within the stipulated times of both the houses of the Parliament is an unconstitutional act by the President. The President should not incorporate any matters in an ordinance which violate the Constitution's on requires and amended to the Constitution. The President should take a moral responsibility when an ordinance elapses automatically or is not approved by the Parliament or violate the Constitution. Thus, it is believed that the POI is the de jure head of the state, where the PM is the de facto head. Executive powers. The President of Indian Union will be generally bound by the advice of his ministers. He can do nothing contrary to their advices, nor can do anything without their advisors. The President of the United States can dismiss any secretary at any time. The President of Indian Union has no power to do so long as its ministers command a majority in the Parliament. As per the Article 53, the executive powers of the country is vested in the President, and it is exercised by the President either directly or through the officers subordinate to him in accordance with the Constitution. When Parliament thinks fit, it may accord additional executive powers to the President per the Article 70, which may be further delegated by the President to the governors of the state per Article 160. Union Cabinet with the Prime Minister as its head should aid and advise the President in performing, but it is the sole responsibility of the President to ensure the compliance with the Constitution in performing their duties. President of their subordinate officers is bound by the provision of the Constitution, notwithstanding any advices by the Union Cabinets. As per the Article 142, it is the duty of the President to enforce the decrees of the Supreme Court. The judicial power. The primary duty of the President is to preserve, protect and defend the Constitution and the law of India per Article 16. The President appoints the Chief Justice of India and the other judges on the advice of Chief Justice. The President may dismiss a judge with two-thirds vote of the two houses of the Parliament. The Indian Government Chief Legal Advisor, Attorney General of India, is appointed by the President of India under the Article of 76(1) and holds the offices during the pleasure of the President. If the President considers a question of a law or a matter of public importance has arisen, they can also ask for the advisory opinion of the Supreme Court per Article 143. Per Article 88, the President can ask the Attorney General to attend the Parliament proceeding and report to him any unlawful functions, if any. Appointment powers. The President appoints as Prime Minister the person most likely to command the support of the majority in the Lok Sabha, usually the leader of the majority party of coalition. The President then appoints the other members of the councils of ministers, distributing the portfolios of them on the advice of the Prime Minister. The Council of the Minister remains in the power at the pleasure of the President. The President appoints 12 members of Rajya Sabha from almost persons who have special knowledge or the practical experience in the respect of such matters as literature, science, arts and social services. The President may nominate not more than 2 members of Anglo-Indian community as Lok Sabha members per the Article 331, which was removed in 2019. Governors of the state are also appointed by the President, who shall work at the pleasure of the President. Per Article 156, the President is empowered to dismiss a governor who has violated the Constitution in their act. The President is responsible for making a wide variety of the appointments. These includes the Chief Justice of India and the other judges of the Supreme Court of India and the state or the union territory of High Courts. Second, the Chief Minister of the National Capital Territory of Delhi, that is Article 239 AA5 of the Constitution. Third, the Comptroller and the Auditor General of India. Fourth, the Chief Election Commissioner and the other election commissioners. Fourth, the Chairman and the other members of the Union Public Service Commission. Fifth, the Attorney General of India. Sixth, ambassadors and the High Commissioners to the other countries, only through the list of the names given by the Prime Minister. Seventh, officers of all Indian services, IAS, IPS and IFS, and the other central civil services in Group A. Financial power. A financial bill can be introduced in the Parliament only with the President's recommendation. The President lays the annual financial statement, that is, the Union budget, before the Parliament. The President can take an advantage out of an contingency fund of India to meet the unforeseen expenses. The President constitutes a Finance Commission every 5 years to recommend the distribution of the taxes between the center and the state. The most recent was constituted in 2017. The diplomatic power. All international territories and the agreements are negotiated and concluded on behalf of the President. However, in the practice, such negotiations are usually carried out by the Prime Minister along with the cabinet ministers, especially the ministers of the external affairs. Also, such treaties are subjected to the approval of the Parliament. The President represents India in the international forums and the affairs where such as a function is chiefly ceremonial. The President may also send and receive a diplomat, that is, the officers from the Indian Foreign Services. The President is the first citizen of the country. Military powers. The President is the super commander of the Indian Armed Force. The President can declare a war or conclude a peace on the advice of the Union Council of the Minister headed by the Prime Minister. All important territories and the contracts are made in the President's name. Pardoning power. As mentioned in the Article 72 of Indian Constitution, the President is empowered with the power to grant the pardons in the following situation. First, punishment for an offences against the Union law. Second, punishment by the military code. Third, a death sentence. The decision involving pardoning, and the other rights by the presidents are independent of the opinion of the Prime Minister or the Lok Sabha majority. In most cases, however, the President exercises their executive powers on the advice of the Prime Minister and the Cabinet. Emergency power. The President can declare three types of emergencies: national, state, and financial, under the Article 352, 356, and 360. In addition to programmatic the ordinance under Article 123. National emergency. A national emergency can be declared in the whole of India or a part of its territory for the cause of war or armed rebellions or an external aggressions. Such an emergency was declared in India in 1962, Indo-China War in 1971, Indo-Pakistan War, and 1975 to 1977 declared by Indira Gandhi. Under Article 352 of Indian Constitution, the President can declare such an emergency only on the basis of a written request by the Cabinet of the Ministers headed by the Prime Minister. Such an proclamation must be approved by the Parliament with at least a two-third majority within 1 month. Such an emergency can be imposed for 6 months. It can be extended by 6 months by the repeated Parliament approval. There is no maximum duration. In such an emergency, fundamental rights of the Indian citizens can be suspended. The 6 freedoms under the rights to the freedom are automatically suspended. However, the rights to the life and personal liberty can be suspended by the Article 21. The President can make a law on 66 subjects of the state list which contain the subject on which the state government can make a laws. Also, all money bills are referred to the Presidents for approval. The term of the Lok Sabha can be extended by a period of up to 1 year, but not so as to extend the term of the Parliament beyond 6 months after the end of a declared emergency. National emergency has been proclaimed 3 times in India to the date. It was declared first in 1962 by the President Sarvapalli Radhakrishnan during the Sino-Indian War. This emergency lasted through the Indo-Pakistan War of 1965 and up to 1968. It was revoked in 1968. The second emergency in India was proclaimed in 1971 by the President V.V. Giri on the eve of Indo-Pakistan War of 1971. The first 2 emergencies were in the face of an external aggressions and war. They were hence external emergency. Even as the second emergency was in progress, another international emergency was proclaimed by the President Farooq Ali Ahmad with Indira Gandhi as a Prime Minister in 1975. Then in 1977, the second and the third emergencies were together revoked. State emergency. If the President is not fully satisfied on the basis of the report of the governor of the concerned state or from the other sources that the governance in the state cannot be carried out according to the provisions in the Constitution, they can proclaim under the Article 356 a state of an emergency in the state. Such an emergency must be approved by the Parliament with a period of 2 months. Under Article 356 of Indian Constitution, it can be imposed for 6 months to the maximum period of 3 years with a repeated Parliament approval every 6 months. If the emergency need to be extended for more than 3 years, This can be achieved by the constitution amendment as had happened in Punjab and Jammu and Kashmir. During such an emergency, the President can take over the entire works of the executive and the garner administration the state in the name of the President. The Legislative Assembly can be dissolved or may remain in the suspended animation. The Parliament makes the laws on 66 subjects of the state list. A state emergency can be imposed via the following. First, by Article 356, if the state failed to run a constituency, that is, the constitutional machinery has failed, when a state emergency is imposed under the provision, the state is said to be under the President's rule. Second, by the Article 365, if the state is not working according to the directions of the Union government issued per the provision of the Constitution. This type of emergency needs the approval of the Parliament within 2 months. It can last up to the maximum of 3 years via the extension after each 6-month period. However, after 1 year, it can be extended only if, first, a state government of national emergency has been declared in the country of the particular state. Second, the Election Commission finds it difficult to organize an election in that state. The Sarkaria Commissions held the President has unconstitutionally misused the provision of the Article 356 many times for achieving the political motives by dismissing the state governments, although there was no constitutional breakdowns in the state. During 2005, President's rule was imposed in Bihar state, misusing the Article 356 unconstitutionally to prevent the democratically elected state legislature to form a government after the state elections. There is no provisions in the Constitution to reprogramulate the President's rule in a state when the earlier proclamation caused to operate for want of the Parliament's approval within 2 months' duration. During 2014 in Andhra Pradesh, President rule was first imposed on 1st March 2014 and it ceased to operate on 30th April 2014. President rule was proclaimed after being fully aware that the earliest Parliament session is feasible at the end of the May 2014 after the general elections. It was reimposed again unconstitutionally on 28 April 2014 by the President. Financial emergencies. Article 282 accords the financial anatomy is spending the financial resources available with the state for public purposes. Article 293 gives the liberty to the state to borrow without any limit to its ability for its requirement with the territory of India without any consent from the Union government. However, the Union government can insist on compliance with its long term when a state has an outstanding loan charged to the Consolidated Fund of India or an outstanding loan in respect of which a guarantee has been given by the Government of India under the liability of Consolidated Funds of India. Under Article 360 of the Constitution, the President can proclaim a financial emergency when the financial stability or credit of the nation or any part of its territory is threatened. However, until now, no guidelines defining the situation of financial emergencies in the entire country or a state or a union territory or a panchayat or a municipality or a corporation have been framed either by the finance commissions or by the central government. Such an emergency must be approved by the Parliament within 2 months by a simple majority. it has never been declared. A state of a financial emergency remains in the force indefinitely until revoked by the President. The President can reduce the salaries of the government official, including judges of the Supreme Court and the High Court. In cases of a financial emergency, all money bills passed by the state legislators are submitted to the President for approval. They can direct the state to observe certain principles, as economy measures relating to the financial matters, the selection process and the eligibility. Article 58 of the Constitution said the principal qualification on one must meet to be eligible to the offices of the President. A president must be a citizen of India of 35 years of age or above, qualified to become a member of Lok Sabha. A person shall not be eligible for election as a president if they hold any office of profit under the government of India or the government of any state or any local or the other authority subject to controls of any of the said governments. Certain office holders, however, are permitted to stand as a presidential candidates. These are the current vice president, the governor of any state, a minister of the union or any state, including the prime minister and the chief ministers. In the event that the vice president, a state governor or a minister is elected president, they are considered to have vacated their previous offices on the date they begin serving as a president. A member of the parliament or a state legislature can seek the election to the office of the president, but if they are elected as president, they shall be deemed to have vacated their seats in the parliament or a state legislators on the date on which they can enter upon their office as a president through Article 59(1). Article 57 provides that a person who holds or who have held office as a president shall, subjected to the other provisions of the Constitution, be eligible for re-election to that office. Under the President and the Vice President Election Act 1952, a candidate can be nominated for the office of the President needs 50 electors as proposers and 50 electors or the seconders for their name to appear on the ballot. Time of election. Article 56(1) of the Constitution provides that the President shall hold offices for a term of 5 years from the date on which they enter their office. According to the Article 62, an election is fill a vacancy caused by the expiring of the term of office of the President shall be completed before the expiration of the term. An election to fill a vacancy in the office of the President occurring by the reason of their death, resignation or removal or otherwise shall be held as soon as possible, after and in no cases later than 6 months from the date of occurrence of their vacancy. And the person elected to fill the vacancy shall, subjected to the provisions of Article 56, entitled to hold the office for the full terms of 5 years from the date on which they enter the office. To me, the constituency of an election to the office of the President not being completed in time due to the unforeseen circumstances, like countermediating of an election due to the death of a candidate or an account of postponement of the poll for any valid reason. Article 656(1)(c) provides that the President shall, notwithstanding the expirations of their terms, continue to hold office until the successors enter into the office. Conditions for the Presidents. Certain conditions per Article 59 of the Indian Constitution debar an otherwise eligible citizen from the constituting the presidential elections. The conditions are: first, the President shall not be a member of the either houses of the Parliament or houses of a legislature or any state. Or if a member of either houses of the Parliament or a house of the legislature of an state is elected President, shall be deemed to have vacated their seats in that houses on the date on which they enter into office as President. Second, the President shall not hold any other office or profit. Third, the President shall be entitled without payment of rent to the uses of their official residence and shall be also entitled to such annulments, allowances and the privilege as may determined by the Parliament by law and until the provision it is that behalf is so made. Such emoluments, allowance and the privileges as are specified in the second schedule. Fourth, the annulment and the allowance of the President shall not be dismissed during the term of the office. Election process. Whenever the offices became vacant, the new President is chosen by an electoral college consisting of the elected members of both the houses of the Parliament, the elected members of the state legislative assemblies of all the states or elected members of the legislative assemblies of the union territories with the legislatures, that is, the National Capital Territory of Delhi, Jammu and Kashmir and Puducherry. The election process of the President is a more extensive process than of the Prime Minister, who is also elected indirectly, elected by the members of the majority party or the union in the Lok Sabha. Whereas the President, being the constitutional head with the duties to the project, defends and preserves the Constitution and rule of the law in a constitutional democracy with the constitutional supremacy, is elected in an extensive manner by the members of Lok Sabha, Rajya Sabha and the state legislation assemblies in a secret ballot procedure. The nomination of candidates for election to the office of President must be subscribed by at least 50 electors as the proposers and the 50 electors as the seconders. Each candidate has to make a security deposit of 15,000 rupees in the Reserve Bank of India. The security deposit is liable to be forfeited in the case the candidate failed to secure 1/6 of the vote polled. The election is held in accordance with the system for proto-provisional representation, that is PR, by the means of instant runoff voting method. The voting takes place by a secret ballot system. The manner of the election of the presidents is provided by the Article 55 of the Constitution. Each electors cast a different number of votes. The general principle is that the total number of votes cast by the members of the Parliament equal to the total number of the votes cast by the state legislators. Also, legislators from larger states can more vote than those from the smaller state. Finally, the number of the legislators in the state matters. If a state has few legislators, then each legislator has more votes. If a state has many legislators, then each legislator has few votes. The actual calculation for the voters cast by a particular state is calculated by dividing the state population by 1000, which is divided again by the number of the legislative from the state voting in the electoral college. This number is the number of the vote per the legislator in the given state. Each elected members of the parliament enjoy the same number of votes, which may be obtained by dividing the total number of votes assigned to the members of the legislative assemblies by the total number of the elected representatives of the parliament. Although the Indian president elections involve actual voting by MPs and MLAs, they tend to vote for the candidate supported by their respective parties. Oath or affirmation. The President is required to make and subscribe in the presence of the Chief Justice of India or in their absence, the senior most judge of the Supreme Court, an oath of affirmation to protect, preserve and defend the Constitution as follows. I, the name, do swear in the name of the God of his solemnly affirms that it will faithfully execute the office of the President or discharge the function of the President of the Republic of India, and who will be the best of my ability preserve and defend the Constitution and the law, and that I will be devote myself to the service and well-being of the people of Republic of India. Emoluments. President pay. Date updated was 1st February 2018. Salary per month was 5 lakh. The President of India used to reserve 10,000 rupees per month per the second schedule of the Constitution. The amount was increased to 50,000, equivalent to 1,90,000 or the US dollar of 2,400 in 2020. In 1919. On 11th September 2008, the Government of India increased the salary of the President to 1.5 lakhs, equivalent to 3.6 lakh or US dollar of 4,400 in 2020. This amount was further increased to 5 lakh, equivalent to 5.7 lakh or US dollar of 7,100 in 2020. In the 2018 Union Budget of India. However, almost everything that the President does wants to do is taken care by an annual 225 million rupees, equivalent to 530 million rupees or US dollar of 66.7 millions. The Rashtrapati Nilayam at Bolaram, Hyderabad and Retreat Building at Chadbara, Simla are the official retreat residencies of the President of India. The official state car of the President is a custom-built, happily and heavily armed Mercedes-Benz Pullman Guard. The former President and the windows and the windowers of the President of eligible for pension, furnished accommodation, silk and various allowances. Impeachment. The Supreme Court shall inquire and decide regarding all doubts and disputes arising out of or in the connection with the elections of the President per Article 71(1) of the Constitution. The Supreme Court can remove the President for the electoral malpractices or upon being not eligible to be a member of the Lok Sabha under the Representation of the People Act in 1951. The subject to the Article 71(3), Parliament made applicable rules or procedures to petition the Supreme Court for resolving the disputes only that arise during the election process of the President, but not the doubt that has arisen from their unconstitutional election qualities. The President may also be removed before the expiry of the long impeachment for violating the Constitution of India by the Parliament of India. The process may start in either of the two houses of the Parliament. The House initiated the process by revealing the charges against the President. The case would be decided by the courts based on the fact furnished by the Union government for the President role. As the clarification by the Supreme Court in the case of Rameshwar Prasad and the other versus the Union of India and other on 24th January 2006. Though the President cannot be prosecuted and imprisoned during this term of office, they can be prosecuted after he or she steps down from the post of any guilt committed during the terms of the President as declared earlier by the courts. No President have resigned an impropriety to continue in the office for declaring and nullifying their unconstitutional decision by the court till now. No criminal cases, at least on the grounds of disrespecting Constitution, is lodged till now against the former President to publish them for their unconditional act. Though many decisions taken during the term of the President have been declared by the Supreme Court as the unconstitutional, mala fins, void, ultra vires, etc. Successions. The office of the President fall vacant in the following scenarios. First, on the expiry of their term. Second, by the reason of death. Third, by the reason of resignation. Fourth, removal by the Supreme Court. Fifth, removal by the impeachment. Article 65 of Indian Constitution says that the Vice President of India will have to discharge the duties if the office fall vacant due to any reasons or other than the expiry of the term. The Vice President revert to their offices when a new President is elected and enters office. When the President is unable to act because of the absences, license or of any causes, the Vice President discharges the President functions until the President resumes the duties. A Vice President who acts or discharges the function of the President has all the power and immunity and is entitled to the same emolument of the President when a Vice President disgraces the duties of the President, but she and D does not function as the chairpersons of Rajya Sabha. Indian Parliament has entitled the law the President Discharge of the Function Act 1969 for the discharge of the functional President when vacancies occurs in offices of the President and the Vice President simultaneously. For example, in 1969, when President Zahir Hussain died in the office, Vice President V.V. Giri served as the acting President of India. However, the late V.V. Giri resigned from both the posts acting President of India and the Vice President of India, as he has become a candidate in 1969. President election in India. In then the Chief Justice of India, that is Justice Muhammad Hidullah, served as the acting President of India until the next President was elected. The President versus the Chief Justice. President versus the Chief Justice of India. First, President. The duties of the President under this oath is to protect, defend and preserve the Constitution and the laws. The Chief Justice of India. Similar to the President, to uphold that Constitution, laws, third schedule of the Constitutionary. Second, the oath is taken in the presence of the Chief Justice. Second, the oath is taken in the presence of President. Third, impeachment by the Parliament with a majority or not less than 2/3 of the total membership of each houses of the Parliament for violation of the Constitution as per the Article 61. Removal from the office by each houses of the Parliament supported by a majority to the total membership of that house and by the majority of not less than the 2/3 of the members of that the house presents and voting on the ground of proof misbehaving or incapacities. President can be removed by the Supreme Court, Article 71(1) for committing the electronic malpractices and upon ceasing to possess the required qualities to be the President. The President cannot remove the judges once appointed by him without the impeachment progress per Article 124. All an individual heads the autonomous institution of the President. Judiciary Supreme Court is also as an autonomous institution represented by a team of Supreme Court judges with the Chief Justice as its chief. President, being the head of the Parliament, executes and supreme commanders of the armed force, is fully empowered by the Constitution to fulfill their judicial responsibility. They can also take the expert advice of Attorney General and also Chief Justice in performing their judicial role. It is a President's duty to ensure that every state governance is carried on in accordance with the provision of the Constitution under the Article 355 and 356. Other Justice Supreme Court is also empowered by the Constitution to repel the unconditional activities of Parliament and Executive only after a free trial. President's prime duty is to prevent an unconditional decision of Union and the state government and the Parliament or the state assemblies by denying their compulsory assent for making them into applicable law. They are the foremost defender of the Constitution who can preempt the unconstitutional activities of the executives and the legislators. The other duties of the President are just ceremonial as the head of the country, which are attached to him for being protector, defender and preserves of the Constitution. The institution of personal President becomes redundant in the President in confined to the other ceremonial duties only. Can intervene or nullifying the unlawful actions of union or state government and unconstitutional law enacted by the Parliament or the state legislatures after presidential action only. The presidents have constitutional immunity for their unsocialism, mala flights, activities during the tenure, but it is liable for judicial action, punishment, and for their unconditional activity after the term of their president. However, per Article 361(1), President is answerable to a court to designed by either houses of the parliament with two-third parties majority for investigating of a charge against him under the Article 61. Chief Justice judges for the Supreme Court are also immune for the punishment for not delivering the correct judgment or for the other incompetent and mala files. However, judges' verdict can be repeated by a higher level bench of other judges. President cannot be recalled by the people of India for not fulfilling their constitutional duties in the case Parliament is not impeaching the President or removed by the Supreme Court. Chief Justice judges of the Supreme Court also cannot be revealed by the people of India in the case of Parliament is not impeaching the judges. Important presidential interventions in the past. The President's role as a defender of the Constitution and the power of a head of a state, especially in relation to those exercised by the Prime Minister as a leader of the government, have charged over times. In particular, presidents have made a number of investigations into the government and law making, which has established and challenged some convictions, proving majority in the parliament. In 1979, Prime Minister Charan Singh did not enjoy a parliamentary majority. He responded to this by simply not advising the president to summon the parliament. Since then, the president have been more diligent in directing the incoming prime minister to convince the parliament and prove the majority within the reasonable declines 2 to 3 weeks. In this interim period, the prime minister are generally restrained from making a policy decision. The proof of majority to form a government. Since the 1990s, parliament election have generally not resulted in a single party or a group of parties having a distinct majority. Until the 2014 Lok Sabha election, when BJP received a clear majority, in such cases, the president have used their director prime minister aspirant to establish this cedinal before being invented to form the government. Typical that the aspirant have been also asked to produce letters from various parts of party leaders, which is the signature of all the employees of the MPs who have pleading support to the candidates. This is an additional to the requirement that a prime minister who proves that has the support of Lok Sabha by a vote on the floor of the houses within weeks of being sworn in the office. Vetoing of a bill. Since the Indian Constitution did not provide any time limit within which the president is to declare their assent of refusal, the president could exercise a pocket veto by not taking any action for an immediate time. The veto was used in 1856 by the President Jai Singh over the postal bill. The President did not give attention to the bill, arguing that there is a scope was that weeping and would give the government arbitrary powers to interrupt the postal communication discriminality. Thank you.